Imagine this. You're a loving parent, providing a safe and nurturing home for your children. But one day, Child Protective Services knocks on your door, and suddenly, your world is turned upside down. Child Protective Services, or CPS, often claims they've made reasonable efforts to keep families together before deciding to remove children from their homes. But what does reasonable efforts really mean? Reasonable efforts is a legal standard, and a low one at that. It doesn't require CPS to exhaust every possible option to keep your family together. Instead, it only requires them to make some efforts up to the point of uncertainty about successfully keeping the family together. This vague and subjective standard means that CPS can justify removing your children even if you believe you've done everything right as a parent. The courts often side with CPS because the bar for reasonable efforts is so low. Many parents are shocked to learn that what they thought were reasonable efforts to keep their family together were not enough in the eyes of CPS and the court. This misunderstanding can lead to devastating consequences, including the removal of your children and even the termination of parental rights. There are also specific situations where the reasonable effort standard does not apply. Since the introduction of the Adoption and Safe Families Act in 1997, CPS is not required to make reasonable efforts to preserve or reunify a family in cases involving aggravated circumstances such as abandonment, torture, chronic abuse, or sexual abuse. Other exclusions include situations where a parent has committed murder, voluntary manslaughter, felony assault resulting in serious bodily injury to the child or another child of the parent, or prior history of involuntary termination of parental rights to a sibling. Individual states may have additional exceptions. Check with one of our expert child welfare consultants if you're unsure about the exceptions where you live. Additionally, the Indian Child Welfare Act requires CPS to use the active efforts standard when a child has Native American heritage or tribal affiliation. Active efforts are more rigorous than reasonable efforts and are intended to maintain or reunite an Indian child with their family. At CPSprotect Consulting Services, we understand the complexities and nuances of the reasonable efforts standard. Combined with the insider experience of our expert team of child welfare consultants, all former CPS investigators themselves, we know how to challenge CPS's claims, help you build a strong case to keep your family intact, and even avoid court altogether. Our experts will guide you through every step of the process, ensuring you understand your rights and make the strategic moves that result in the best outcome available to you. Don't let the vague and low standard of reasonable efforts result in you experiencing every parent's worst nightmare. The earlier you get help, the better and swifter the outcome will be. Get equipped to preserve your rights and protect your family now by visiting CPSprotect.com or calling toll-free at 844-633-KIDS. Your family's future could depend on it. CPS Protect Consulting Services, protecting families, preserving rights.